0910. Do I have anyone here on this case?
Bruce Shapiro, I'm here, Your Honor.
Good morning, Mr. Shapiro. How are you? I haven't seen you in a very long time.
Been a very long time. I still had dark hair then.
All right.
Yes, Your Honor. Patricia Vaccarino. I'm here as well.
Wow, this is nice to see you as well.
Thank you, Your Honor.
All right. Sorry, let me get. All right, so this is on for Caroline Jensen's motion to disqualify the judge. Ms. Vaccarino?
Thank you, Your Honor. Probably at this point, knowing this court, you have reviewed the papers. You probably know a lot more about this case than you might want to. And I would note that our motion did focus on disqualification under the Nevada Code of Judicial Canon 2.11. It's well supported under that Rule 2.11, as well as under the Tobin and PETA versus Veracini cases. We specifically outlined and attached as to our submission of exhibits the apparent three issues that look as if and appear that the Judge Perry has a bias in favor of the defendant and against the plaintiff for three separate reasons. It appears that the opposition and the judge's untimely response that was filed on April 29th really more focuses upon trying to defend the decision, which is really not before this court. And that's why our reply went back and tried to set the record straight on some of that. However, Your Honor, it is clear that, if you're considering the response to the motion, it was untimely filed, I guess it would still be considered by the court. But that clearly shows that Judge Perry, in fact, has not denied the bias. And I know the rule clearly states, have been on both sides of this issue, that only a judge knows whether or not he or she is biased. They may not always recuse themselves. But in this case, since the response, although untimely filed, only 4 pages long, denies that Judge Perry is not biased against women. We have not made that allegation of bias. We made 3 separate allegations regarding pro per litigants, military office members that had issues with the Uniform Code of Military Justice, and parents wanting or not wanting joint physical custody. And Judge Perry has clearly made extrajudicial statements that have been attached and filed in the record with an unofficial transcript of her interview when she with a licensed clinical social worker, where she has specifically commented on these issues of bias. That brings it all within the jurisdiction, showing that we've made a proper and good faith motion for removal. I've seen when a judge files a response and she adamantly denies the specific allegation of bias, and this has not happened in this case, Your Honor. Since we filed our motion, we did in fact order the transcript from the January 12th, 2021 hearing. It was recently filed. And there are very interesting comments, because that decision from the bench was made on January 12th, and Judge Perry makes it very clear on page 13 of that transcript that everything else was done in good faith by both sides. Bruce Shapiro, who's a very worthy advocate, recently came on the case, even argued at page 5 of that transcript that there had never been any finding in the case that anyone filed a frivolous motion, and he, in fact, agreed there was no prevailing party, and that is part of how the judge changed her decision. She made a mistake on who did not submit the preliminary order before Judge Steele at the hearing on January 12th. I had begged her to please go back, take it under advisement, read it carefully. That was actually the defendant's responsibility to prepare the order. We submitted the order, and Judge Steele's chambers erroneously struck it as a supplemental exhibit and we had to file, she struck the whole record, we had to file a motion to reinstate the record. And at that first January 12th hearing, the judge was very clear that the only thing she was willing to grant fees for to either party was where she felt the case, quote, went sideways. That's at page 13 of her transcript, when the, quote, plaintiff did not submit the order as she was ordered. And then her order in chambers, she struck that, erased the $10,000 that she thought would have been due to the defendant for the proceedings of reinstating the record and the order not being filed. And then in her 3 months later, she was going to let us argue it further, removed it from the calendar on March 1st and waited until April 12th and made a decision that totally contradicts the statements she made. Another concern is that the bias is shown because even in her decision and her response, she contradicts what she said in her initial review of the case on January 12th on page 14 of the transcript, line 7. She states that both law firms, referring to both law firms that had represented the defendant, exhibited a great deal of professionalism in keeping this case moving towards settlement, as did you, Ms. Vaccarino. The attention to detail and keeping the eye on the ball was excellent. And then again, at line 17, she states, but for this area brought about by plaintiff's failure to prepare an order in January 18, I would not be awarding fees at all. I believe all other issues was fair and accurate. And then she goes on to state at page 8, line 19 of the transcript, both parties were mule-headed at certain points. And at page 22, line 19, she again refers to the collective attorneys, me having represented Caroline, and the other attorneys that had represented Sean were, quote, a bunch of very good attorneys. So legally, Your Honor, if you read the decision, if you see the extrajudicial statements, if you see that she calls my client's conduct unbecoming in her decision, which is a military province, it doesn't even lean over into civil work, I believe you are compelled to find that a reasonable person would objectively question the impartiality of this judge. And for all of these reasons, Your Honor, we do believe that you should grant the motion for removal. Recognizing that it's rarely done, but we have made our case, and there has been no opposition in the record that would satisfy, that should satisfy this court that removal should not be granted at this time.
All right. Mr. Shapiro?
Yes, Your Honor. Judge Perry had barely been on the bench for a week. She had never met either party. She read the pleadings. She heard the argument. She issued her decision. She then reconsidered her decision, re-reviewed the pleadings, and issued a confirming decision. There's no reason to question her impartiality. Bias, if any, came from her review of the pleadings and her second review of the pleadings and the positions that plaintiff took. There's nothing to even argue that Judge Perry could have possibly had any bias against the plaintiff, or her impartiality could have been reasonably questioned other than what she learned from the parties in the pleading. If the law is going to be, a judge is recused because the judge looks at you wrong or says something you don't like or you disagree with the decision, the judicial system is going to come to a halt, particularly in family court. The bottom line is that the plaintiff takes exception with the judge's decision. The remedy here is an appeal, which plaintiff is pursuing. The remedy here is not a disqualification because you disagree with the decision. You ask the Supreme Court to review the decision to see if there's anything inappropriate. So our position remains that there's no basis for disqualification and the motion has no merit.
All right. Anything else, Ms. Vaccarino?
Briefly, Your Honor, again, this case is more in line with the PETA case, where it's not per se that she is reading the issues in the case. She has made extrajudicial statements that show that she has a predisposition, that she is unable to sit. She has preconceived notions set forth in the law that do not allow her to come to the bench and objectively view a similarly situated litigant like Caroline. And clearly, when she makes extrajudicial biased and derogatory statements and then tells us not to say anything about the defendant's military record, we were trying to show that he had committed, got charged with felonies. in the military, and that they had to do with finances, which bled over into his disingenuous nature in this case that caused the delay. When we're told at a hearing that we're not allowed to bring that up and cut someone down, when we're just trying to argue the merits of who acted in good faith throughout the case, and then this judge goes back to Chambers, we didn't know about these comments she has, against, persons that are, well decorated in the military, and the concern of having the military code of justice breathe down her or another's neck. That made her mad. It clearly did. She went back, had a bias towards Caroline. How dare we say this about him? How dare we not agree to joint custody? When the only issue allegedly was who didn't do the order. So it's very clear that if you look at the law, it states clearly that if a judge is unable to hear the case without having these preconceived notions, if she's made a public statement other than in a court proceeding, judicial decision or opinion, that commits or appears to commit the judge to reach a particular result or rule in a particular way in the proceeding or controversy. That's Rule 2.11 that allows for disqualification. That is what's happened in this case.
I'm struggling a little bit with that because, she made comments about the military and being in the military.
Right.
I feel like I know she makes mention of it in the order, but I'm not sure I'm fully putting the link together from the comments that she made to how, so can she not hear any case involving somebody who is in the military?
No, I believe that she made it clear in her extrajudicial statements that she had the military code of justice breathing down her neck. And so did the defendant in this case. So she has a sympathy or a bias towards him. She has also clearly made these extrajudicial statements that we were not aware of until after the decision, and we did some research, that she has a huge bias in favor of pro per litigants. If you look at her decision, she's cutting Caroline and I down constantly, saying that we took advantage of him, that he had a right to fight, that he didn't have an attorney, and I had a duty to explain the labels to him, which would violate other law. And one other thing, Your Honor, she has a clear disposition for joint physical. You can see in her decision that we had allegedly taken advantage of him. When the Rivera case says, no, you agree to what you agree to, then a judge has to count up the days over the last year of what you actually have shared. So it's all three of those issues, Your Honor, where she's made those statements. And we're saying in this case specifically, with all three of these going on, and with the decision she has rendered that cuts Caroline and I down and sanctions us to an extensive extent that definitely contradicts her prior findings in the record, that in this specific case, not in every case, but in this specific case, it definitely falls under 2.11 A5, that she has made these public statements, other than in the court proceeding that we have filed with the transcript, that appears to commit the judge to reach a particular result or rule in a particular way. And that's what we're telling you. All three things she said in the last year prior to issuing her decision, actually it was 14 months because her decision was finally entered in April. Those statements were made in February or March of the prior year when she was running for judge. All three of those things together in this specific case, each case has to be looked at specifically, warrant disqualification, especially under A5. And that is the one that basically is very fact sensitive. It's not just a blanket statement about her. It's specific allegations made about Caroline that are untrue or that don't follow the law, don't follow the procedure of this case. And they trail back to her extrajudicial statements made in applications for judge, as well as in her transcript with the Donna Wilburn, the licensed marriage family therapist. So in this case, I'm not saying every case that everyone will file such a motion, because maybe if she gets this decision, she'll realize that she has to keep her implied feelings or bias or her preconceived notions of what's fair or right for a pro per litigant, or what's fair or right for someone who has had the Uniform Code of Military Justice down their neck, and for someone who does not necessarily want to share joint physical custody. If you're not sharing it, you don't get to come in and have this judge ram it down your throat, and if you didn't agree to it, or if she feels he had a right to fight for it, that she's going to be biased against someone like Caroline, and indeed Caroline in this case. That falls under the PETA case. It wasn't from a review of the papers. It was from an affiliation the judge had with the PETA organization. It definitely is analogous to that case, Your Honor. We believe in this specific case, not every case, removal is warranted of this judge.
All right. Anything else, Mr. Shapiro?
Yeah, I mean, Judge, the statements while a candidate is making while being interviewed, running for judge, dicta in a hearing that has nothing to do with the decision, I mean, you could probably link anything that any candidate says to any decision and argue some type of vague implied bias. Custody wasn't at issue here, so her statements regarding, favoring joint custody, which the law also happens to provide, is not relevant. The defendant wasn't even in proper person when the proceedings began. That wasn't relevant. Again, there's no issue of bias. She disagrees with the decision. And I'll note that after the judge initially heard the matter and awarded the defendant $10,000 in fees, there was no motion for bias filed. It was after the reconsideration and fees were increased from $10,000 to $15,000, that's when the motion for recusal was filed. So the original decision, they weren't going to question her objectivity or bias. It was only after the fees were increased on the reconsideration. And again, all the decisions that Judge Perry made will be subject to the Supreme Court review on the appeal.
All right. Thank you both. I will issue a written decision.
Thank you.
Nice seeing both of you. Have a good afternoon.
You as well.
Judge, sorry to interrupt. This is Aaron Shipley. Did I hear you correctly a few minutes ago that the Ben matter is continued 2 weeks?